Thank you. I'm George Kanoupis. Thank you for inviting me to speak on mediation in the courts in the United States of America. I'm an American lawyer and a Greek lawyer, but I'll be speaking in mediation in civil cases in the courts in the United States. I'd like to thank OPAMED and the Hellenic American Chamber of Commerce for inviting me. When you go to Philadelphia, in the middle of Philadelphia Square, there's City Hall, and on top of City Hall, there's Benjamin Franklin. And when you make a left, you go down Market Street. And when you go down Market Street at 8th and Market, there's the Mediation Center of the Federal Department of Labor. And on the 13th floor, in the penthouse, you go up and there's the scary investigation section, where the federal government investigates you for labor violations. And on the right side, there's the non-scary mediation section. And as you walk into the mediation section, there's a big sign that says the following quote: "I was never ruined but twice, once when I lost a lawsuit and once when I won a lawsuit," by Voltaire. And that is a very important quote when you go into mediation. And so I'm here to discuss the evolution of alternative dispute resolution in the United States, focusing on mediation because arbitration is fundamentally different. And as we heard Professor Kotsiris, who I have the greatest respect for, say, mediation was begun, the idea of mediation was begun by Justice Burger, who in 1984 spoke very strongly about mediation in the United States. And he said the following words: "Our system is too costly, too painful, too destructive, too inefficient for a truly civilized people. To use the adversary process as a principal means of resolving conflicting claims is a mistake that must be corrected. The entire profession has become mesmerized with the stimulation of the courtroom contest. We should be healers. Should lawyers not be healers?" So with that, began those strong words by the Chief Justice, began an impetus toward mediation. Now, before I left the United States, I had already prepared my PowerPoint. Mr. Katsigiannis, who I have the highest respect for, asked me for some statistics. And of course, I didn't have time for statistics on mediation and the economics of mediation, but I did find one. And it was from the United States Justice Department. The United States Justice Department is the group of lawyers that form the U.S. Attorney's Office that prosecutes federal crimes. And it's approximately 93 offices. And in 2016, they estimate that they saved $70,610,000 using mediation, and 26,388 days of trial expenses. And so that's one statistic. I suppose I'm not a statistician. There is a lot more statistics like that out there, but again, that's not what I know. But the evidence is quite strong, and I'm going to provide you some statistics as I speak. So 3 initial questions to get us started. Why compare the ADR legal systems of different countries? Well, because comparative legal analysis is one of the best tools in international law in improving a legal system toward rule of law, which has efficiency as one of its hallmarks, because justice delayed is justice denied. And so that leads us to the critical question: why does mediation work so effectively in the United States in civil cases? It's a question we have to ask. Why discuss the U.S. Department EOC mediation program and federal court magistrate mediation program in my presentation? Because the EOC mediation program has a 70% settlement rate, and the federal judge magistrate mediation program has a settlement rate in excess of 40%. Why discuss U.S. versus Greek civil procedure and Greek court systems quickly in the ADR process and solutions? Because mediation can best be understood and implemented in that context. How mediation and alternative dispute resolution in general gain momentum in the U.S. And this is important. You heard one of the colleagues at the conference the other day, I think it was from the Netherlands, talk about this idea of ADR, alternative dispute resolution, beginning in the US in the 1990s. Well, this is how it began. The first big act, called the Biden Act, after Joe Biden, who became the vice president, the Civil Justice Reform Act of 1990 was a big legislation in the United States. It implemented something radical, something called case management procedures, to include early court-annexed mediation. These case management procedures had three foundations that are very critical if you're looking about how these things go about, especially if you're looking about how you may implement such things in another country. And other countries did look at this. Italy looked at this. Other nations looked at this. Three foundational things that are of critical importance. One, it instituted empiricism and data gathering as part of the Administrative Office of U.S. Courts, using empiricism and data gathering, constantly monitoring individual judges. Number two, instituted the fundamental proposition that you cannot buy time if you're a judge by rescheduling your calendar if it's busy to a future date. Number three, it made judges responsible for local docket management, implementing the idea of a judge manager. Those three were radical ideas that were implemented at that time. Those were followed by the second act, the Administrative Dispute Resolution Act of 1996, that implemented the same procedures for administrative agencies. And thirdly, the ADR Act of 1998 now came in with the final push and made alternative dispute resolution and mediation mandatory in federal court litigation. So the keys to effectiveness of this in the federal court system in the United States, administratively and in the courts: support by the bench and bar, properly trained neutrals, program adequately administered by the courts, early neutral evaluation with the effect of a greatly reduced backlog. What has been the effect of this since the 1990s? Only 4% of federal civil cases go to trial today. Great reduction in the backlog of federal court systems in the United States is implementation. So why is this so successful? After all, we're talking about one of the most litigious nations on earth. 300 million people, 800,000 lawyers, and a jury trial as a matter of right in almost all civil matters. That means the litigants know that they don't have to worry about a judge making a decision. They can get a member of their peers, 8 or 12 people, and take a shot for justice. They can have their real day in court, their peers, people they see on the street, even more motivated to go to trial. Why does it work? Well, let's get a little specific. We have to. There's no other way to understand why it works. I'm going to go through this very quickly. In federal court, the system implements mediation intrinsically. We begin with the filing of the complaint. The filing of the complaint is a simple matter. It involves a short, plain statement of the facts. The facts have to be true, or else there are sanctions under the rule. And as you can see on the other side, parallel course, the answer is due fairly quickly, within 30 days. Service must be made fairly quickly. An answer must be made fairly quickly. And if you're going to move to knock the case out on any legal issues, you have to move fairly quickly. But going back on the left side, immediately a judge is assigned within 30 to 50 days, and a conference is scheduled in front of the judge within 30 or 50 days. The judge schedules what is called the Rule 16 conference with a magistrate judge. That is another judge called the magistrate judge assigned to the case specifically to manage the movement of the case. The judge requires, every case is referred to a magistrate judge. Every case is referred to a magistrate judge for a settlement conference. The parties, before the case is referred to a judge for a settlement conference, for a Rule 16 conference, must file a disclosure that states how long they're going to take discovery, interrogatories, depositions, when they're going to file their motions, and when they expect to go to trial. They can't take more than 120 days to do this. An order is entered, then referring the case to the federal magistrate judge for a conference. The magistrate judge contacts the parties. Again, this is within 30 to 60 days of the case being filed. And the judge sets up a settlement conference in the federal courthouse. An order is issued. The settlement conference, the judge's order rather, requires the parties with their, requires the trial counsel with their parties having actual settlement authority to appear. In advance of that appearance, the parties must submit a written memorandum, 3 to 5 pages, summarizing their case with their damages, including a demand from the plaintiff. On the day of the conference, which is in the courtroom with the judge in robes, with the client looking in the federal courtroom at the jury box, looking with the judge in the robes, the judge implements a caucus methodology. That means he listens to the one party, listens to the other, separates the parties, and then goes into caucuses. Tell me about your case, tell me about your case. This is what I think about your case, this is what I think about your case. Now, you can tell the judge something that the judge is not to tell the other side. Now, I have a particular opinion about that, how it doesn't work in a lot of ways, how you shouldn't do that, but that's something to be discussed as part of the questions. But you can do that. The judge, by the way, before this is done, asks for your permission to talk to the parties ex parte, because the judge is not supposed to talk to a party without the other party being present and their lawyer. So that's done at the beginning. If the case doesn't settle, the magistrate judge does not tell the actual judge what happened at the mediation, only that there's an impasse. If the case settles, the case is over. The important thing to remember, without going into too much detail, all of the above is put into motion by impetus of the court within the first 3 months of filing the complaint. The other thing to remember is, while all this is going on, the other requirements of the scheduling order of the court, that you must begin discovery within those 3 or 4 months. That means you have to take interrogatories, you have to take depositions, you have to take expert witnesses, also starts running. Usually the settlement conference with the judge, the mediation with the judge, is done before that. But if you don't settle with the judge, you have to start that discovery process, which is very expensive. If you don't do that discovery process, you don't survive what is called the Rule 56 motion, the motion for summary judgment. So you know you're in for quite a bit of expense. You're not going to get the trial if you don't enter that conference. So this is one of the reasons why mediation, magistrate judge mediation works so well in federal court litigation in the United States. It's implemented as part of the Code of Civil Procedure into every civil trial. And I can explain that in greater detail. Moving along very quickly, how does mediation work in the federal agencies? I'm using this as one example, but it basically works the same way in all federal agencies. The Department of Labor takes all complaints or charges for discrimination for any private company. Any labor dispute, any discrimination dispute is filed with the Department of Labor, Equal Employment Opportunity Commission, or other agencies. When you file that charge of violation, the EOC immediately, the federal agency, gets thousands of these. 10,000 are filed every year in Philadelphia alone. If they want to be referred to the mediation unit, before the investigation unit begins its investigation. If both parties agree, it goes into mediation. The investigation is frozen until the mediation unit advises. This is very important because once the investigation begins, if you settle the case, you have no guarantee that the federal government is going to go along with it. Because the federal government doesn't care if you settle the case. The federal government begins its investigation and finds a violation, then it's too late. You settle the case, the federal government may very well say, no, we're not settling the case. You will not be able to obtain money from your employer because you will have settled the case civilly, but the federal government can pursue the company for damages, punitive remediation, and other punitive expenses. Worse yet, the federal government may, of course, prosecute the company. So it's very important to a lot of companies to mediate, to choose mediation at that point because they know that it's done before the investigation begins. Again, the mediation date is set. It's free, just like the federal judge mediation. It's free at this point. It's provided by the court. Lawyers must attend. Mediator is neutral. Now, in this case, it doesn't have to be a lawyer. It could be a human resources expert. It could be a lawyer, but in this case, administrative, it doesn't have to be a lawyer. The parties sign an agreement to mediate in confidentiality. No one that's there can talk about anything that happened in the mediation or use anything that is said in the mediation at trial. The parties make a short statement. The mediator only has the charge of the parties and a brief response by the respondent. The mediator hears a short statement, and then we go into caucuses. And it takes all day. The mediator negotiates back and forth. If there's an agreement, it's signed, the federal government signs off on it, and it's done. It's done. It's settled right there, and it happens. 70% of the cases that go to mediation settle. I have a 40% success rate in mediation personally, and I've done over 300 mediations at DOC over the last 15 years. So I'm very, very, very happy and very, very successful with the mediation procedure. So the conclusion to this is U.S. administrative law and federal court civil procedure is designed to incorporate mediation effectively using federally appointed mediators and federal magistrate judges. Since specific legislation in the 1990s made ADR a mandatory and integrated part of the federal administrative and court dispute resolution process, efficiency has been increased and backlogs have been significantly reduced. Potential discussion topics. What are the impediments to the utilization of mediation in reducing civil court and administrative docket backlogs in Greece? Do the amendments to the Greek Civil Code of Civil Procedure provide a greater opportunity or impetus for mediation? And/or what changes are needed to the Greek civil court system and civil procedure system to better incorporate mediation so as to reduce backlogs? Number 3, are there other impediments to mediation in Greece, such as we've heard, lack of trust in the system, a feeling that there's no justice unless you get your day in court, other impediments? Number 4, and finally, could Greece adopt broad civil justice reform legislation, mandating and implementing mediation effectively, as was done in the U.S. in the 1990s? And let me just say, the U.S. had a similar problem. The backlogs in the U.S. were almost as bad as in Greece in the 80s and the 70s. I'd like to thank you very much. Again, I'd like to thank the chambers.